Welcome to our Housing and Consumer Protection Subcommittee of the House General Laws Committee. We've got a few bills on the docket today. We'll try and move through them fairly quickly. And we can start with, we don't have a sign-up sheet. We just get to be kind of capricious about it here. Delegate Hackworth, you've got a fire prevention code one. You've been sitting here because you were here for the earlier one. Why don't you come on forward and we'll hear Senate Bill 1248.
Thank you, Mr. Chair, members of the committee. Senate Bill 1248. And this bill was brought to me by one of our small communities in Tazewell County, the Burks Garden community. And the local firefighters there, they are trained to do the fireworks displays, and there is actually a fee in the code that when you're doing that, the fire marshal has to come out, has to perform inspections, and that is a $300 permit fee and then $95 an hour to pay for an on-site state fire marshal. So what they asked us to do, and we did some research, there was only one such permit in the state of Virginia. And so this bill actually just says on lines number 25 in the substitute, serving a locality with a total population of less than 10,000. And so it just exempts those localities that are doing that has less than 10,000. Really helps small communities like this because it could be, $2,500 or something like that for the fee for them by the time travel charge stuff is. So we would just ask, it came through the Senate with full support. And we just ask that you consider and pass this bill. So,
Senator Hackworth, it doesn't say you don't have to get the permit. It just says the permit has to be free if the locality is under 10,000 people.
Yes, the fees associated with getting the permit would be no cost to that locality. Yes, that's correct.
Well, did this go through Senate Finance too?
It did go through Senate Finance. There was no fiscal impact. They said there was one, and I think it was $300 or something, said no fiscal impact. Okay. I have that if you need it.
All right. Any questions from members of the subcommittee for Senator Hackworth? All right. Anybody in the audience wishing to speak in favor of the bill? Anyone in opposition to the bill? All right. Committee operates by motion. Second. Moving to second of the bill report. The clerk will open the roll. Members will cast their votes. Clerk will close the roll. Senator Hackworth, your bill reports 8-0. Thank you very much. Mm-hmm. All right, Senator Craig, you have been sitting here for a while as well.
Thank you, Mr. Chair, members of the committee. I bring to you Senate Bill 934. I serve on the VOLSAP, the Volunteer Firefighters and Rescue Squad Workers Service Award Program, along with Delegate Thomas, and this came from our meeting. Basically, the VOLSAP is a service award program. It's authorized under the Internal Revenue Code and the Virginia Code. It's eligible volunteer firefighters and emergency medical technicians, and they can contribute money to this fund, which is invested alongside the VRS Trust Fund. In addition, their agencies or departments can make additional contributions on behalf of the participants. The bill allows unclaimed funds in the program to be transferred to the unclaimed property program with Virginia Treasury. Current law provides that the unclaimed funds remain in the fund. Unclaimed VOLSAP funds will be presumed abandoned for unclaimed property purposes 5 years after. So basically, the VRS in the program, we're just keeping the money in their petty cash fund. And so I brought it up at our meeting that nobody really knows if 10 years from now, 20 years from now, someone passed away, they would know to go to this. And it's only a couple thousand. I said, let's, after 5 years, transfer it to the unclaimed, that's, a known program through the state, and that's what this bill does.
Got it. Understood. Anybody on the subcommittee have any questions for Senator Craig? Delegate Thomas.
Mr. Chairman, I would just commend the patron for bringing this bill and also say that in tandem with Delegate Hernandez's bill about unclaimed property, this would be an extremely efficient process.
All right, sounds good. Anybody in the audience wishing to speak in favor of the bill? Anyone in opposition? All right, committee operates by motion. Second. It's been moved and seconded that the bill report. The clerk will open the roll. Members will cast their votes. The clerk will close the roll. Bill reports 8-0.
Thank you. Y'all have a wonderful day.
Welcome. Senator, who's behind the podium? I can't see you all there. All right. I think Durant, you were here, and then I'll have Perry, and then Favola, and then Rome, and then maybe Marston. All right, Senator Durant.
Good afternoon, Mr. Chair, members of the committee. We've got Senate Bill 1282, and there was Delegate Thomas did carry the House version. This is reporting the federal government's transitioning to this National Fire Incident reporting system.
I'm going to interrupt for just a second. So this is identical. I think this maybe was one that just got missed. Probably could have been on the earlier docket. Is this identical to your bill?
It should be, Mr. Chairman. I'm just not 100% sure whether or not was it amended out of the Senate.
Yeah, I think I just saw there was some slight language amendments, and I just spoke with the folks that brought it to us, and they're perfectly fine with it. So if they're to go with the amended language from the House is
Yeah, Mr. Chairman, I just move we amend it to the.
So there's a motion to conform to properly seconded. As many as favor that motion will say aye. Those opposed? All right, so it's conformed. I'm just saving you some time. And it's been moved and seconded to report as conformed. As many as favor that motion will say aye. Oh, no, we got to vote on this one, sorry. So it's report with substitute.
I just need to amend.
Substitute.
Thank you.
Clerk will close the roll. This bill votes, reports by a vote of 8-0. Thank you,
okay.
Senator
Thank you
Durant.
very much, Mr. Chair.
Senator Perry, you ready?
Good afternoon, Mr. Chairman, members of the committee. This is Senate Bill 884. This is a bill that deals with, that amends the current law. The current law, it deals with protective orders and the termination of leases as a result of a protective order. The way the law currently stands, you could terminate your lease if you gave 30 days notice to your landlord and you had a permanent protective order entered or a conviction in a criminal case. That was in cases of sexual abuse and domestic violence only. The issue with that law and the way that it works is that the point is to try to give victims of very specific crimes a way to terminate their lease early so that they can essentially escape an abusive situation. They may not be able to pay rent in multiple places. The problem with the law, though, is that typically to get a conviction in a case, certainly more serious cases of domestic violence, those serious cases or your sex cases, it can take years to get there. And by that point, you're probably not stuck in a lease anymore. Your lease is probably already terminated. And the issue with protective orders, oh, well, maybe you can get a protective order faster. Sure, sometimes, but if there's a criminal case, any prosecutor worth their salt is going to have that protective order trail behind the criminal case because they're not going to want to have that victim up there testifying multiple times. And so essentially what the law does as it stands now is not a whole lot. The intent of it has been sort of diminished by the way that the system works, for lack of a better word. So what this bill seeks to do is back up in time. Several other states have taken a slightly different approach to this issue by allowing for your psychologist, your doctor, right? A lot of mostly women who experience domestic violence and sexual abuse don't always go to law enforcement. So they've allowed doctors and psychologists to write letters to landlords saying, hey, this person is a victim. They provide notice and then terminate their lease. I took a slightly different approach to that because I did want at least a third party to have a neutral third party to have some say. So this bill provides that for an emergency protective order, which is the earliest protective order in the system, that 72 that you can get initially whenever the violence happens, or a preliminary protective order, if those are issued by a magistrate or a judge at that point in time, once you have one of those in hand, once a neutral third party has said that there's probable cause to believe, as required by the code, that person is a person who within a reasonable period of time has been subjected to an act involving violence, force, or the threat that resulted in bodily injury or places a reasonable person in fear of death, sexual assault, or bodily injury. And I read it out because it's a very specific definition. There's a lot of things that happen that don't fit that definition. It's a pretty high standard. But if a magistrate or judge were to issue a preliminary protective order, an emergency protective order, or a permanent protective order, at that point in time, you could give 30 days notice to your landlord so you could terminate your lease and get out. On the other side, on the charging side, backing it up a little bit, if a magistrate were to issue the first part in that process, the magistrate finding probable cause to believe a crime involving domestic violence has occurred, a crime involving sexual assault has occurred. If they were to issue a warrant or a criminal complaint, or a grand jury were to return an indictment in those types of situations, you also could take that document, take it to your landlord and give 30 days notice, pay your last 30 days. You still have to pay it under the statute as it exists now, and then be able to terminate your lease. I also extended the types of crimes that would be covered to include stalking. Seems like the exact type of crime where you would want someone to be able to terminate their lease early, and human trafficking. And so that's what the bill does. I'll tell the members of the committee that the bill came out of Housing Sub unopposed, the Housing Commission Sub unopposed, Full Housing Commission unopposed. Since that time, the apartment complexes have come here and they don't like the bill because I guess they're afraid they might lose some money. I understand it might be $1,000 a month, maybe. But this bill really seeks to protect victims of some of the most serious crimes we see in our country, and particularly the most vulnerable victims in those situations who cannot afford to pay double leases, double rent, may not have another family member or person who can give them housing. The Emory School of Medicine and a lot of other groups talk about that the most dangerous time for a victim of domestic violence or sexual assault is in the period of time when they seek to leave their abuser.
So,
Go ahead.
Secretary, thank you. So I just didn't want to interrupt. I want to make sure we're wrapping up. So I love almost everything about this bill. I think it's a great bill. I like the expanded list of offenses. I think that's fantastic. I like expanding it to the preliminary protective orders. I think that's very good. The one thing that gives me pause, and maybe help me understand why I shouldn't, is the emergency protective orders in particular, right? Those are only good for 72 hours. I guess, so here's my question about that for a second. If I go to a magistrate, I swear out an affidavit, he finds me credible, says or she says I'm credible, and says there's probable cause to believe that I'm likely to be a victim of one of these things. I get it. I leave the courthouse with this document that's going to expire within 72 hours. I take it to my landlord. Is my lease terminated at that point? Or if that 72-hour emergency protective order expires and no preliminary protective order is ever issued and that's the end of it, does that lease continue? In other words, I think the way that some folks are reading this, and maybe some of the pushback you've been getting, is I take that emergency protective order, that terminates the lease. I just have to wait out the 28 or 9 more days, pay the rent, but the lease is actually terminated, and then nothing further happens with that emergency protective order. Do you understand what I'm asking?
A little bit, Mr. Chairman, and that's not exactly the objection I've heard, but the objection I've heard about emergency protective orders is actually slightly different. But what I would say about that is that one, the statute still lays out that once you provide notice, if you were to get that emergency protective order, then you take it to your landlord, you're still on the hook for the last 30 days rent. So the answer to your question about does it terminate immediately, the answer is no. You would still have to pay the last 30 days rent, even if you have a 72-hour protective order. And look, the reason that I drew the line there was sort of going back to the points I made earlier, right? A lot of other states, New Jersey, other states, have allowed for your psychologist, your doctor to write these letters, because the vast majority of women, I think I was just reviewing the Emory School of Medicine website, like only 25% of the women who are domestically abused ever go to the police, right? We're talking about a very small group of women. This bill has been really narrowly hewed to begin with. I could have sought to provide those other providers, and I'm not saying that's an unfair policy decision. I think it would probably be fair to do that. What I'm also not trying to do, though, is to require, again, primarily women to repeatedly have to go back for an emergency protective order, a preliminary protective order, and the permanent protective order to get that coverage. And so I think the emergency protective order or the preliminary protective order, again, backing it up in the system, provides still the protection of a magistrate, right, where you duly swear under oath, right, the facts and allegations that you're making you subject to a perjury, a felony charge, should you come in and lie about it. And should the judge or magistrate find, a judge or a magistrate can, either one of them can issue, pursuant to 19.2.152.8, can issue an emergency protective order. Should they find that you meet that standard, right, that within a reasonable period of time you are going to be subjected to death, serious bodily injury, or sexual assault, should they find you meet that criteria, then the emergency protective order is issued. That 72 hours, again, going back to the critical nature of that immediate time, the time in the most immediate time when they will be able to terminate their lease, and at least they can get out of the house and know they don't have more than 30 days to pay. I'll be honest with the members of the committee. I've had some people come up to me and say, hey, Russ, can't you remove that last 30 days? We do think it should be an immediate termination, that they should be able to walk away. And again, I've erred on the side of, hey, let's try and put some protections in. Maybe later on we'll say, hey, we need to come and do more. But I do think that immediate ability to bring what you have and start moving that 30 days process, if we were to back it up further, the 30 days, according to the statute, wouldn't start running until you have that later protective order.
Gotcha. All right, any other questions from members of the subcommittee? All right. Yes, Delegate Arnold.
Thank you, Mr. Chair. Mr. Chair, I have a question for council. I'm concerned about the language used in this here, and as I understand it, and so it says the victim has obtained an emergency protective order, which doesn't define if it's still active or if it's expired. And then it says in subsection B that a tenant who qualifies to terminate such tenant's obligations, which is referring to, I guess, A2 there. So my question would be, does this language allow someone to obtain an emergency protective order, never move forward with the process, and still then give notice to terminate sometime after the expiration of the emergency protective order?
Mr. Chairman, Delegate Arnold, if I'm understanding your question correctly, I believe it could be read that way. I will admit that emergency protective orders usually fall under courts or public safety, so it's a little outside of my wheelhouse. But
Thank you, guys. I tend to read it the same way as Delegate Arnold. I mean, it's a if this then that kind of a statement here. Delegate Coiner.
Mr. Chairman, supportive of the bill, and
I'm sorry, Mr. Chairman, can I just answer the delegate's question?
Sure.
We talked about this and we dealt with this issue. We wanted to make sure that we were dealing with a protective order that's issued during the period of an active rental agreement. And so I think if you turn up to line 22 of the bill, it says, given written notice of termination in accordance with subsection B during the period of the protective order and the extension thereof. So I think that's the language that sort of hews in that this has to be while the protective order is in effect.
So that's on line
22.
But I think Delegate Arnold was asking about lines 23 through 26, sub 2, where it says you've obtained an emergency protective order during the term of the active order, given written notice of termination during the time of the protective order or any extension thereof. So it's there again in line 26 as well.
Yeah,
right,
sorry, yes.
Thank you.
Same language, yes.
Thank you, Senator Perry.
Yes, I'm sorry. Yes, Mr. Chairman, Delegate Coiner.
Delegate Coiner.
thank you, Mr. Chairman. So have been supportive of this. We heard it at the Housing Commission, and supportive of the concept. I will say there were some things that I sort of thought maybe might be worked on a little bit between then and here, because I think a few people on the dais at Housing Commission were like, is this perfectly clear? And in particular, looking at the emergency protective order in those short 3 days and how easily you can go get one, and the result of that for folks who are living places, like is it going to be used to displace people? So because you wouldn't just be maybe terminating your own lease, you could also be terminating the other person who you live with lease, because if you're both signed on to it, it could result in not just you being able to break your lease, but everybody no longer going to be able to be there if you were the financial person who was on it. So that's the only piece that I was still trying to think through, between fully supportive of the concept and what you're trying to do, but that's the piece I'm still trying to figure out with that short period of time, the impact it might have on other people in the household as well.
Mr. Chairman, Delegate Coiner. Yeah. I think that's, I think the Southern Poverty Law Center, I think that's sort of what they say is like, couldn't this be abused? Couldn't it be misused? Couldn't the abuser run to the magistrate's office and get a protective order, right? Couldn't they meet that arduous standard? Like, to be totally honest, in practice, I'm not entirely certain what all law you practice, Delegate, so I don't mean any disrespect. Okay. These protective orders are actually relatively difficult to get. In my domestic violence cases, in my divorce cases that I have now, there's a lot of terrible behavior that goes on that does not qualify you for a protective order. It's much more difficult than people think. It's not harassing behavior that doesn't qualify, right? Like a lot of things do not qualify. It's actually pretty serious. And I think that question, and so a couple things, what protects that run, right? Like one, we have a neutral third party magistrate, the same person that issues warrants in criminal cases, right? What's stopping someone from running and getting a warrant for stalking or domestic violence or any of the other crimes, some sexual assault, rape? What's stopping people from doing that, right? And abusing the system? It's the same question, right? This is just on a lower scale. We're talking about termination of a lease, right? We still allow magistrates to make those determinations in much more serious cases. And so I think that's one thing. And so what's one of the reasons we don't see people just doing that by and large in mass droves, right? I think I saw in my entire time as a prosecutor, about 10 years, I saw one case where someone went and got a protective order. You know what happened to that person? Where they just blatantly lied. Do you know what happened to them? I charged them with perjury, a felony, and I convicted them of it because it's very, very serious. We want to be able to trust our system. We want to be able to trust that when people go to the magistrate and say, this is what happened to me, that we believe them,
Gotcha.
right?
All right, Delegate Coiner.
Thank you, Mr. Chair. I guess my concern is still, having walked through with a family dealing with a protective order, the example I will give is one I was walking alongside folks, siblings, brother has mental health issues, sister is at home. He punched her and she called the police, rightfully so, and ended up with a protective order, but magistrate ended up allowing with the parents to figure out how to keep them in the same house, but keep them separate. There were rules he had to follow. But in that case, either one of them could have used this in that situation to make it where you can make other people leave or they could leave. I'm still not certain that in those temporary situations that I feel comfortable. I'm still trying to figure that piece out.
Mr. Chairman, if I could.
Briefly, we get that you don't think that fraudulent emergency protective orders is a terribly big issue, but go ahead.
My point's actually a separate one from that.
It's a different one.
And to be fair, I had a couple more points I wanted to make on the last question, but I'll just say this. The emergency protective order is a temporary protective order. The preliminary protective order is also, that's a 14-day order. You're talking about this same period of time. So if you're worried about things being up front, which is exactly the point, is to exactly protect the people in the most vulnerable situations, then you essentially have gutted the entire protective order portion of this bill. Just to be fair about that. And secondarily, this only allows person, I don't know about this brother or sister situation, but they would have to decide like, hey, I don't want to be separate and apart in this house, and I'm on the lease, right? This is not about, hey, I live here and I'm going to go blow up mom and dad's lease, right? That's not the way that this works. You would have to be a person legally on the hook for the lease.
Let's hear from somebody. Is there anybody here in favor of the bill that wants to testify in support of the bill? Step forward. All right, anybody in opposition to the bill that's willing to be heard? Come forward. All right, go ahead. Please identify yourself. We know you, but for the record, explain.
Thank you, Mr. Chair.
Concerns about the
Erin
bill.
Corman with the Realtors. We sat on the Housing Commission this summer. We were concerned about the same things that you guys are talking about. We support the bill. We support the concept. We've worked on this bill for several years prior to this point with Delegate Delaney, and we still have concerns about that emergency protective order. It's termination automatic at 72 hours. The preliminary can be extended. We don't have any issues with the rest of the bill. It's just the emergency protective order. Thank you.
Thank you.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. I want to echo the comments of the previous speaker and just say that we were also on that Housing Commission work group, and we moved the bill forward with the understanding that we were going to continue working on it. But the piece that does concern us is that emergency protective order. Thank you.
All right, thank you.
Mr. Chair, members of the subcommittee, Zach Lemaster with Gentry Law Consulting here on behalf of the Northern Virginia Apartment Association, and we would just associate our comments with the previous speakers.
Thank you.
Mr. Chairman, members of the subcommittee, Christy Marrow with the Virginia Poverty Law Center. And like the other speakers, we do appreciate the intent of this bill. We greatly appreciate the senator's intent to protect victims of all of these heinous crimes, but do have concerns specifically with the emergency protective order language. And the Senator alluded to the fact that our concern is that it would be misused because we know that sometimes abusers get emergency protective orders as a further form of control and abuse against the victim. So that is our concern with the emergency protective order piece. Thank you.
All right. Anybody? We don't have anybody online. All right. Any more questions from members of the subcommittee? So, Senator Perry, I realize you feel very strongly that you like the bill the way it is. We try and be a little more consensus. I don't know if it's more or not. We try and be consensus oriented on this subcommittee. Is there any appetite on your part for moving this bill forward without the emergency protective part in?
Mr. Chairman, with all due respect, I don't think that makes any sense. I think that those comments is a misunderstanding of the process. What is the difference between if an abuser, for instance, abuser goes to get an emergency protective order? I know we like to make everyone happy here in the General Assembly, but that just doesn't always happen. I don't expect the apartment complexes to love that someone can terminate their lease early. I don't expect them to, and they're not going to, and that's okay, right? This is protecting poor and marginalized women. That's what the bill is for. They want to get their money, that's fine. I think this bill makes a balance that's fair, right? That's okay. It's okay. It's okay to tell people no sometimes, right? My point is this about the emergency protective order. If an abuser, let's play it out, an abuser goes to get an emergency protective order, right? That's in front of a magistrate. You know what they do in the preliminary protective order that happens at that 72-hour mark? They get their preliminary protective order without having a hearing by the other side. They can continue that. There's nothing that stops that except for the system, except for the guardrails that are already present in the system. There's nothing about the emergency protective order that is different than the preliminary protective order except for how long they last. 72 hours versus 2 weeks before you could potentially be before on a permanent protective order. But as I said, in the most serious cases where there's criminal charges pending, that can be years and years down the line. With all due respect to Delegate Delaney, right? I think that's part of the reason the bill originally was drafted the way that it was, because it doesn't really do anything. Right? This bill seeks to do something. This bill seeks to enact the intent to protect those most vulnerable people who are in very specific domestic violence, sexual assault, human trafficking, and stalking offenses to allow them to get out of their leases so they have somewhere safe to go, so that their abusers, their stalkers, their rapists don't know where they are.
Right. So let me ask you this question. The advantage of the emergency protective order is, as I understand it, that they're not paying double rent for another 3 days, right? And that's really, because the issue is they're not waiting the 30 days of the lease to leave and go be safe, because we all share that concern. We all want them to be safe. So if we make them, if they can't use the emergency protective order, they're still not going back to the apartment. Would you agree with that?
Mr. Chairman, I don't know. I don't know if they're going back to the apartment or not, right? I don't know. I mean, the hope would be, right, that they would have somewhere safe to go. But if you say, well, first of all, I don't understand the logic behind it, except for it makes some people feel better. But logically, I don't understand the waiting another till the preliminary protective order is issued at the 72-hour mark, right? That's when it would be issued, right?
Right. But I'm trying to understand the advantage of your approach, right? You don't understand the logic of their approach. I'm trying to understand what the advantage is. Here's my compromise. And just because I'm a softie and don't really understand and just like to make people happy, my suggestion would be if we got rid of emergency protective order, changed the 30 days to 28 days, right? So then they're not paying double rent. We're going 4 weeks instead of 30 days, and they can terminate the lease a little bit earlier, which you said was something you wanted to get rid of that lease a little earlier. So we got rid of emergency protective orders, and we made the termination effective 28 days. We're kind of splitting the baby there, or splitting the difference. And I don't know if anybody on the subcommittee would like that idea. That was my thought for a compromise, because I do like to make people happy. What can I tell you?
I think it's a great idea.
All right, it's been moved and seconded that we take out emergency protective order and shorten 30 days to 28 days. Because we like to make people happy here in the House of Delegates. All right, moved and seconded. Those in favor of that motion will say aye. Aye. Those opposed? All right, the motion is agreed to. It's been moved to report as amended. Is there a second? So it's moved and seconded. The question from Delegate Thomas was whether we think that because of some of the protective order issues and where we might have some folks ask. I'll put it to Senator Perry.
I'm sorry. I'm a little bit of a hard time hearing you.
I'm sorry, and I apologize for my voice, and I'm mumbling a little bit, so I'll confess to all those things. The question from Delegate Thomas was would this benefit from another look at the Courts of Justice Committee, where we might have some more folks who have more experience with the protective order process and so forth? Or would you rather we just go ahead and report it as amended, as it is now?
I defer to you on that. I'm happy to go, have these same arguments with other folks, or you cannot.
Delegate Coyne.
Mr. Chair, I don't see the benefit of it going to courts. I think ultimately they're going to say it's a housing issue and kick it back to us.
All right,
And I
we
think
don't want to ping-pong it back and
we
forth.
risk
All right.
it not being heard.
All right, so the motion, which was properly seconded, is that we report with amendments. The clerk will open the roll. The clerk will close the roll. The bill reports 6-2. Thank you,
Thank
Senator
you.
Perry. All right, Delegate Rome. Oh, sorry, Delegate Favola.
You made senator. That's okay. That's okay.
Wrong line. So many.
If you vote
so
out
many
my
levels.
bills, you can call me Delegate Favola.
All right, Senator Favola.
Thank you. Mr. Chairman, there are two bills before you. I'll start with the first one at the lower number, Senate Bill 754. This should look very familiar to you. What it does is, under our Consumer Protection Act, it specifically says that reproductive health information or sexual health information shall be protected if it is willfully released without the consent of the owner of that information. Then there would be a private right of action. It's very straightforward.
It does look familiar. Where did I see that?
Doesn't it look very familiar to you? I think this is essentially a bill that you carried last year. HIPAA information is exempt from this, and we say that specifically. Having presented the bill, I hope it is the will of the committee to move it forward. And I did put it under the Consumer Protection Act rather than our Data Protection Act, because there is no opportunity for a private right of action under our Data Protection Act. So that's why as you led the way, I kept it under the Consumer Protection Act. That's the bill.
All right. What an excellent bill presentation with lots of praise for the chairman. I like it that way. Any questions for the patron? Everybody understand what this bill does? All right. Is there anyone in the audience wishing to speak in favor of the bill? Please come forward.
Mr. Chair, members of the subcommittee, Jenny O'Halloran on behalf of Planned Parenthood Advocates of Virginia, and we support the bill.
All right. Anyone here to speak in opposition to the bill? Seeing none, the committee operates by motion.
Second.
It's been moved and seconded that the bill report. The clerk will open the roll. Clerk will close the roll. Bill reports 6-2. Senator Favola, you have another bill.
Okay, thank you, Mr. Chairman. This next bill is very easy, Senate Bill 842.
You just jinxed
It is a Section 1 bill, and it is a recommendation from the Joint Commission on Healthcare. It directs the Department of Community Development to actually move forward with our broadband programs to support mobile health clinics. And this would this is a big deal in our underserved areas. It should make some aspects of healthcare more affordable and more accessible, and we can use our federal broadband equity access and deployment programs. So that's the bill, and I hope it is the will of the committee to move it forward.
All right. Any questions from members of the subcommittee? Anyone in the audience wishing to speak in favor of the bill? Anyone in opposition? Oh, sorry. It's been moved and seconded that the bill report. Clerk will open the roll.
That's a wonderful,
Clerk will close
wise
the roll.
vote.
8-0.
Thank you. Hope you have a great evening.
Favola. Senator Rome. Oh, and as long as we're thinking, before I forget, Senator Marsden disappeared because he decided he'd like to have his bill go by for the day to see if he can't work it out. Moved and seconded that SB 1376 go by for the day. As many as favor of that motion will say aye. Aye. Those opposed, no. All right, the motion is by, that bill is by for the day. So we are down to Senator Rome.
Well, hello, Mr. Chair. Hello to my title attorney. Hope you all are
Welcome
doing
back.
great today.
Well, full disclosure, right? We once had an attorney-client relationship.
Things were great. So today's bill is SB 1055, and my dear friends, I want to first say thank you so much to the delegate from Chesterfield for helping me out with the preceding version that we all passed last year, SB 281. What that version did after 3 years of me, gnashing my teeth over that, was to make sure that you had interment rights to be buried next to your family who's buried on a family cemetery located on private property. We created this whole section of code where you could go into court, you can make a whole case, evidence out. It took a while, we got it over the line, and everyone was happy. So with that in mind, the ask this year is one line on this, which is on lines 22, 23, where it says, or public property owned by a county, city, or city, town, or other locality or held in trust for such a locality for use as a cemetery. So the reason for that is we have instances right now where we have family members who want to be, or living family who want to be buried next to their family, located on cemeteries that were former heirs' properties. They were taken over by a local government, and now they're having a difficult time with that. And so I'm just going to read to you a quote from my constituent who's not here to testify. He just asked me that I say this, and then that'll save stuff down the line. Okay. So he said, "We only want to remain with our loved ones. My family has been laid to rest beside each other for over 200 years in 3 different family cemeteries. Our family cemeteries, all within walking distance of each other, on land once owned entirely by my family. When the county purchased land around these cemeteries, they stripped us of all burial rights without pause. When my cousin passed away suddenly a short while ago, we had to beg the county for over a week to allow him to be rested beside his mother. Now my 82-year-old mother is being denied the right to have her brother rest beside their brother. We've always had the peace of knowing our family would always be together, even in death. Now that has been taken from us after 200 plus years. This is important for public land because a county can simply revoke all burial rights at will, despite its obligations to the people they are there to represent, leaving a community and or family devastated by a loss that is avoidable."
Thank you, Senator Rome. Anybody have any questions or comments from the committee? Delegate Coiner.
Mr. Chair, and maybe council can, don't shout at me. I think I've worked in this code section enough with the senator that I think this is correct. So the intent is you want to be buried in an identified family cemetery, and it's either, which we worked on before, located on private property owned by somebody other than the family, or now 2, public property owned by a county, city, town, or other locality, or held in trust for such a locality, and your family cemetery is on it. I think you actually need to delete the for use as a cemetery, because the way that's worded, it's the localities using it as a cemetery. You just want that the first part is correct, is buried in an identified family cemetery located on 1, the private property, 2, public property, and it should end after held in trust for such a locality. You don't need the rest for use as a cemetery, because they may have been given a whole park, right? The whole thing is a park, and your family cemetery is located somewhere within the park. They're not using the public property as a cemetery. They're using it as a fill in the blank. Your family cemetery habit. I just think for it to do what you want it to do, you don't need the for use as a cemetery.
So, Mr. Chair, that's a friendly amendment if council is okay with it.
Council.
Mr. Chairman, Delegate Coiner, Senator Rome, that works for me. I also have an additional technical line amendment if you're amenable to it. Where it says owned by a county, city, town, or other locality, I think we can actually delete or other locality, since locality is defined as county, city, or town, and just amend that to say county, city, or town. Or if you would prefer it to just say locality. I just don't think we need both.
So, Mr. Chair, I guess the question I would have is, would the new language just basically be beginning on line 22, where it says, or Romanet 2, public property owned by a county, city, town, or county, city, or town, and then that's it?
Or held in trust for such a locality.
Or held in such
locality there, I think probably we drop the county, city, or town. We just go.
Okay, got it.
Report the amendment would be, or 2, public property owned by a locality or held in trust for such a locality.
Yeah, sounds good.
Everybody get the line amendment? Is there a motion on that? All right, it's been moved and seconded to adopt the line amendment. As many as favor of that motion will say aye. Aye. Those opposed? All right, the amendment is agreed to. Any further? So is there anyone in the audience wishing to speak in favor or opposition to this bill?
It's really good. Oh, thank you.
Somebody over there said something. All right. Committee operates by motion.
Second.
Been moved and seconded to report with amendment. Clerk will open the roll. The clerk will close the roll. Senator Rome, congratulations. Your bill report's 8-0.
Thank you so much.
Everybody's happy about it. All right. I believe that completes our business. The committee will rise.